Welcome to the Greater St. Louis MGMA May 2022 webinar. Before we get started, we have a couple of quick housekeeping items. All attendees will be in a listen-only mode. The chat feature will be used to take questions, so please feel free to submit your questions at any time during the presentation by clicking the chat icon at the bottom of your screen. Questions will be addressed at the end of the speaker's formal remarks. Today's webinar is being recorded, and a copy of the recording and any available slides will be posted on our website under the online education section of your member center. Thank you for joining us for the May 2022 webinar entitled Top HR Laws and Regulations That Every Organization Should Know, presented by Brian Bisking, Peggy Manuel, and Francine Martin of Synchrony Hr. I am now going to turn the controls over to our presenters.
Thank you. Good morning, or good afternoon, I guess I should say, everybody. My name is Brian Bisking. I'm the Vice President of Sales for Synchrony Hr, and I will get us started here today. Oh, sorry, a little touchy. So let's go over the agenda real quick. So today I'm going to kind of introduce who we are here at Synchrony Hr, so you guys can have a little background about our organization and what we do. Then we'll tackle three of the top HR laws and regulations that are pretty much on everybody's minds these days. And those three topics are medical marijuana, the exemption statuses, and terminations, how to properly terminate employees. With that being said, we'll dive straight in. So who is Synchrony HR? Synchrony HR is an HR outsourcing firm dedicated to protecting employees and strengthening businesses. We're headquartered right here at the corner of Olive and 270 here in St. Louis. We've been in business going on 7 years. We were actually started by an insurance agency here in St. Louis called Cornerstone Insurance Group, if you guys ever heard of Cornerstone Insurance Group. And we were formed back in 2015. Like I said, locally based here in St. Louis with clients in over 45 states and growing. We had a 40% growth rate last year as an organization, which we're very proud of. Our mission is to create lasting, reliable relationships with each of our partners and to provide proactive services, solutions, and technology on an ongoing basis. We are a certified professional employer organization accredited by the ESAC Corporation, which stands for Employer Service Assurance Corporation, a nationally recognized financial assurance standard setting and accreditation entity for the PEO and HR outsourcing industry. We are also a member of the National Association for Professional Employer Organizations. So let's talk about our first topic, which is medical marijuana. So in the last several years, obviously this has become a bigger and bigger topic. We now are, facing even recreational marijuana and the usage of it being legalized in several states. Currently today, there are 33 states that have legalized medical marijuana. 11 states have legalized recreational marijuana. I know the recreational marijuana is on the ballot, I believe, for Missouri for this year. And so it'll be interesting to see kind of how that plays out here in the state of Missouri. Colorado allows, which is what was the first state to legalize medicinal marijuana, allows employers to not hire candidates if they test positive. However, Missouri law does not contain this such language. And we're going to dive into the language here in just a minute. A blanket prohibition can put employers at risk. So we are advising clients to be very careful on the language that you're using when you are writing handbooks and putting policies and procedures in place from a medical marijuana perspective. We always advise our clients, to use your HR resource partner to your best way possible to help write the proper language to kind of minimize the risk as an organization. So let's review Missouri's Amendment 2 law, which legalized the medicinal marijuana purposes. So the law actually prohibits marijuana in the workplace during work hours. That's very key to remember, that it's during the work hours. It does, however, does not address workplace testing or changing your drug testing policies that may have existed before the law passed. Therefore, employers can continue to drug test if they so fit. So if you had a drug testing policy in place previously, you can obviously continue to work through that, or you can put a new one in place as well. Also, Amendment 2 for the state of Missouri or any other state or federal law mandates employers must allow medical marijuana in the workplace, even if the employee holds EHSS medical marijuana card. So that's also another very important note to kind of keep in mind. The law does not prevent employers from disciplining or terminating an employee who tests positive. Some notes about the marijuana. Obviously, marijuana can stay in your system for up to 30 days. A variety of ways that it can be tested for: hair testing, blood testing, urine samples, things along those lines. If an employee tests positive, it is, however, recommended to postpone disciplinary action and to determine whether the drug test result was connected to lawful use. I apologize. So kind of to reiterate what the slide is saying is, going back to the first point, it's prohibited to use marijuana during work hours, but if an employee has a medicinal card, legally they're allowed to use that marijuana after work hours, okay? And it also states that the law does not prevent the employer from disciplining, though, or terminating an employee who does test positive. So kind of can be kind of confusing there, so you gotta read those points very clearly. The Missouri employee can ask for accommodations for medical marijuana. So the employer should confirm that the worker does have their medical marijuana card, and they'll adhere to any company drug policies, including refraining from use while on the job. So again, going back to the previous slide, it's very imperative to have a good policy that not only follows the law, but the rule of the organization, and having that in your handbook that's been signed off on by the employees. As we mentioned in the previous two slides, recreational use is not legal currently in the state of Missouri. So if an employee tests positive without holding a medical marijuana card, not only have they broken your company policy, but they've broken the law. So it's very important to kind of keep in mind when you're looking at your policies and procedures and how to properly put them in place. If an employee is properly certified and tests positive, the only clear right an employer has at this particular time is to prohibit that employee from being under the influence while at work. So again, going back to the previous slide, you can't necessarily tell a person who has their medical marijuana card they can't smoke marijuana, but you can have policies in place that allows them to do it obviously during work hours or being impaired while they're at work. This means the employer will have to carefully document an employee's behavior that has led to the employer to believe that the employee was under the influence while at workplace to do a drug test. Due to this risk, it's recommended to seek legal counsel prior to taking any adverse action. So again, just to kind of reiterate the section on this marijuana is, it is, if an employee has that medicinal card, they can certainly use that cannabis product after hours, just not during your work hours. And again, kind of another key point in this particular slide is making sure they're not impaired when they're at your actual location working during the location. If you sense an employee is impaired while they're working on your premise or your property, it's very important that you consult legal advice, your HR department, your partners, if you have an HR partner, kind of like a Synchrony Hr, to make sure that you're documenting that behavior and that you have the right to do a drug test at the organization. From that, we will move on to exemption status. So I'm going to enter Peggy Manuel, who's our Director of Operations. And Peggy, I'll let you take it from here.
Excellent. Well, Brian, I surely don't have a topic that's as heated as that, but sometimes it seems like it is as heated. I'm going to talk about the exemption status today. And it's one of those things that clients, when I talk to them, I'm an HR professional by trade. Everybody wants to pay everybody a salary. And when they do so, they always assume that that means that they are exempt from overtime. So today we're going to talk a little bit about hourly versus salary and exempt versus non-exempt, and have some examples of what that might look like. So to start, one of the biggest misnomers that I run into with my clients is the referral to anybody that that they refer to as salary as them assuming that they are non-exempt. So hourly versus salary, it's important to know that it doesn't define whether an employee is exempt from overtime. So I always tell people, throw out those terms, hourly versus salary, when it talks to that. Hourly versus salary is really all about how a person is paid, not whether they're exempt or exempt. Non-exempt employees, for example, can be paid in hourly or on a salary basis. Hours, regardless of how a person is paid as a non-exempt employee, must be tracked, and overtime is due regardless of how they're paid. Now, it's important to know that under the Fair Labor Standards Act, it's not just a nice to have that you're tracking hours. It's actually a requirement of the employer to track the hours of a non-exempt employee. On the flip side, an exempt employee, you do not need to track hours, and an exempt employee, one of the characteristics of being exempt is that they are paid on a salary basis. So what determines if an employee is exempt or non-exempt is really based upon the job duties and pay. The Fair Labor Standards Act, if you kind of put in your mind frame the fact that the government really intends for everyone to be paid on an hourly basis, and an exempt employee is actually an exception to the rule. It's a defined exception under the Fair Labor Standards Act with criteria that you have to meet. So an exempt employee, unlike non-exempt, is someone who doesn't get overtime, nor do they qualify for minimum wage. And most exempt positions actually must meet the minimum wage threshold. A non-exempt employee is eligible for overtime and must meet the minimum wage thresholds, whether it's on a federal or a state level. So requirements for an exempt employee. First of all, one of the very first requirements is that they have to be paid on a salary basis rather than hourly. And they must earn above the Fair Labor Standards minimum threshold, which is currently at $684 per week. And that's what this next one says, minimum threshold $684, $35,568. You may remember a couple of years ago, they tried to take this up to, I think, like almost $900. Again, that sends the message that everyone, the government really wants everybody to be paid hourly, and this is intended to be an exception. The job duties, so beyond just looking at salary, exemptions generally only apply to people who are in professional roles, or the role requires a higher level of expertise or knowledge or influence on matters of significance. And as I mentioned, each one of the exemption statuses actually has a fact sheet under the fair. You can Google fact sheets, the exemption fact sheets, and they tell you specifically what those job duties are, and they do an excellent job of defining the job duties. So to first start with the exemption status for the executive exemption, so this job must be primarily managing the enterprise or managing a customarily recognized department or subdivision. They have to direct the work of at least 2 or more full-time employees. And it's important to know, if you have 2 managers that are managing the same people, the same 2 people, that doesn't count. They have to each have their own 2 people to qualify under this. They have to have the authority to hire or fire, make suggestions or recommendations. And while their decision may not be the final, it has to be given a particular weight. It has to actually make a difference in the decision. The next classification is the administrative exemption. I think this is the one that is probably most mismanaged, if you will. So first of all, an administrative position obviously is an office job. It's not somebody who's out in the factory moving widgets and doing things like that. They have to be responsible for exercising, and these words, I really beg you to read the fact sheet on this, exercise independent judgment or discretion over things that are of matter of significance within the organization. It's not, like I need 25 boxes of pencils and I know when I go down to 15, I got to order it. It's things that really make a difference. And this is a fact sheet that the DOL has done a great job of defining every one of those terms so that you can do a good job of documenting why you have classified an administrative role as exempt. The professional exemption, this is one that requires advanced knowledge. The work is intellectual in character and requires consistent exercise of judgment. So you would see a doctor or an attorney probably fall in this one. Advanced knowledge must be in the field of science or learning, or require a prolonged course of study in a specialized area. In continuing on this topic, the primary duty must be performing work requiring advanced knowledge, just like we said. Oh, this is actually a duplicate here. So we can go on to the next one, just to make sure you got it the first time. So let's go on to the creative professional. This is one that's really pretty unique, and it sometimes, again, people think, well, just because a job feels creative in nature, that's all under here. We're usually talking about folks in music, writing, acting, graphic arts. It's performance of work requiring invention, imagination, originality, or talent in a particular area of art or creative work. An outside sales exemption is actually the only exemption that doesn't have a salary requirement. The outside salesperson must literally be an outside salesperson. So if you have someone sitting at a phone, taking orders, doing things like that, they're doing sales, but they don't go outside, they are not considered exempt. They may not be exempt at all. So they could probably be a non-exempt, kind of order taker, if you will. So their work outside of the business only exempt I said that. Okay, onward. Thank you. The computer exemption, again, another one that I think is a little confusing for people. This one does have a salary requirement of the 684, but it also provides a hourly salary or an hourly requirement if they are compensated hourly. This is the only exemption that allows consideration for an hourly wage rate or payment on that level. And notice, if you read through the things on here, they're employed as a computer systems analyst, a programmer, software engineer, or some similar field. It's not usually anything that requires manufacture or repair of computer hardware. So somebody who's on the phone really doing things that have to do with, you call into a center and somebody's helping you fix or diagnose something. Those jobs are not considered exempt. And this is an exemption that's pretty specific as to what computer specialties would fall in the exemption role. The highly compensated, this is one that really people don't usually talk about because they usually also qualify under something, but some other classifications such as the admin, the professional, are typically the executive exemption, but this is one where someone's earning over $107,432,000 a year. Why they picked that crazy number, I'm not really sure, but similar as the other exemptions. Again, I don't typically talk too much about this one because they qualify elsewhere. So exempt versus non-exempt, some examples. An exempt administrative employee who provides, for example, support to production or operation. That might include like human resources, accounting, maybe your legal executive, public relations, finance, payroll. But again, read the thing. It's all about independent judgment, making decisions on matters of financial significance. Exempt executive, CEO, managers, supervisors. Now, if your supervisors, again, consider 2 or more, consider the level of the supervisory versus being in a manual or a manufacturing role. Consider those things because the Fact sheet will also say on there that their primary duty must be. So kind of keep that in mind. Exempt professional employees, doctors, lawyers, engineers, nurses, architects, teachers, and other roles that require advanced knowledge. Creative professionals, we talked a little bit about some of these, the writers, actors, musicians, journalists, composers, outside sales. Again, they have to be outside the building doing sales or marketing. And then computer related are programmers, software engineers, and system analysts. We talked a little bit about this. Again, the non-exempt employee is paid an hourly wage and is subject to overtime provisions under the Fair Labor Standards Act. They must earn at least the federal minimum wage for every hour worked, and overtime for anything over 40 hours. Many states at this point have minimum wages that are more significant than the federal minimum wage. So please pay attention to that if you're moving into a new state and you have hourly employees. Take time to understand not only what the minimum wage is, but what other laws might apply to your non-exempt employees. Wait, like lunchtime. California, if you're going to California ever, let the buyer beware. Any job that earns minimum wage is eligible for overtime and does not meet the exemption, the qualifications for exempt. Okay, so they're guaranteed non-exempt employees. All right. I think that's it. I did good.
Yes, thank you so much, Peggy. So now we're going to talk about terminations. Making the decision to terminate an employee and conducting the termination meeting are two of the most difficult responsibilities for managers to have. Knowledge of the laws and best practices, as well as training, help both the manager and the employee end the relationship on a positive note. And it's essential that all managers, in addition to human resources staff, acquire appropriate knowledge to make these important decisions and to conduct professional termination meetings. This presentation is going to provide you with that knowledge. So let's talk about types of terminations. Voluntary. An employee provides a resignation stating his or her intention to leave the organization within a specified period of time. So some of the reasons for voluntary terminations include a new job, maybe personal reasons like relocation, health, family obligations, retirements, or job abandonment. Some types of or involuntary termination is the employer initiates termination of an employee's employment. Reasons for involuntary terminations include unsatisfactory performance, where the employee fails to satisfactorily perform the essential functions or to meet established goals for the position. Extensive absenteeism and tardiness. Organizational change includes layoffs and reductions in force, or misconduct is violations of the employer's code of ethics and conduct policies, practices, procedures, or rules. So Missouri is an employment at will state. Employment at will is a doctrine. It is not a law. Employment at will pertains to the employer's right to terminate the employment relationship at any time for any reason, with or without notice, as long as the employer does not violate oral or written contracts, public policy, or the covenant of good faith and fair dealing. Documentation. So to establish credibility and to support your termination decision, you must objectively document incidents, poor performance, and conversations with the employees. Be sure to include in your documentation the following: the dates of any incident or conversation between you and the problem employee. Documenting events shows that the decision to terminate an employee is supported by a record of prior incidents. A record of violations of policies or procedures such as poor performance, absenteeism, insubordination, disruptive behaviors, and unethical behavior. Whenever possible, include the language that the employee used and how the incident affected your department or the company as a whole. And continued, and this is continued, details of conversations you had with the employee and any disciplinary actions you took in response to the employee's performance deficiencies. Also note realistic guidelines you gave the employee and deadlines you set for improvement. Employee appraisals performed, details of meetings that took place to determine an employee's progress toward established goals, and notes regarding the employee's level of participation throughout the process. A record of giving verbal or written warnings to the employee must sign a document that acknowledges receipt of each warning. So before the termination meeting, review with your HR professional to ensure alignment with the action and proper documentation, have written notes for what to communicate, time the meeting carefully, hold the discussion in private, schedule a conference room in advance if necessary, and consider having a representative from HR or another manager in the room. And during the termination meeting, try to avoid small talk, remain calm, clearly state the reason for termination, avoid personal references or accusations, make it clear that the employee is terminated and that negotiation is not possible. Be prepared for the employee's reaction. Discuss all issues that need to be closed, like benefits, final paycheck, company property. Provide a copy of the separation notice and walk the employee to the exit of the building if security is not available. So some final requirements for termination. If the employee is involuntarily terminated, the final paycheck is generally due on the day of discharge. The exception is that this requirement generally does not apply in the case of an employee whose remuneration is based primarily on commissions and whose duties include collection of accounts, care of stock or merchandise, and similar activities, and where an audit is necessary or customary in order to determine the net amount due. If the employee quits, Missouri law does not address the final paycheck requirements when they do quit. So payment of unused benefits on termination. Missouri law does not address the payment of unused benefits upon termination. Generally speaking, an employer who has agreed either in written or oral policy or by practice to pay employees for accrued but not unused time off should include such payment in the final paycheck, whether or not the state has enacted a specific law to that effect. So for more information regarding final paycheck, that's available on the state site of Missouri. Okay, so now we are ready for any questions that you may have.
Oh, great. If anybody has questions, feel free again to use the chat icon at the bottom of the screen, and we will just kind of read them off as they come in. So I will give it a few minutes and see if anybody has any questions. It looks like we don't have any. What I can do is if anybody does, oh wait, take that back. I fibbed a little. Is there a penalty if the employer doesn't provide a check upon termination?
Francine, I would be happy to answer that question.
Okay.
The Missouri state law will talk to a penalty, but the reality is, if you were to read the regulations around not providing a, they're not very scary. So as an HR professional, I will tell you that I don't, I try and have our clients provide a check whenever it's possible. And when it's not, typically the employee has to request in writing The fact that you haven't paid them, you have a certain amount of time to respond, and then you might be subject to some kind of a penalty. The reality is, by the time that they have put it in writing to you and you have responded, you have typically processed that next payroll and the person has been paid their final wages. So, and just even same thing, going to the final wages, to talk for 1 second about payout of PTO. In the state of Missouri and in many states, the states say they don't require a policy on PTO, they just require you to follow your policy. So if you have not done so, take a look at your policies surrounding PTO and determine whether or not you speak to it. And if you don't, I would suggest you update your handbooks to speak to what happens when a person leaves. It really should not be something, same thing on, practices even around paying people, try and pay them out when you can, but it's important if you do the mentality of what you do for one, do for all. So if you're going to pay out PTO for one, then you pay it out for all.
Thank you. I did want to ask, while people were kind of maybe thinking of questions, is there a way that we could get your contact information just in case, maybe tomorrow somebody has a question? I can attach it, in an email to everybody.
Sure.
Okay, excellent. Well, we do want to be, very cognizant of everybody's time. So I do not see any other questions coming in. I don't want to rush anybody either. So I can give it, like another minute or two and see if anything comes to anybody's mind. Well, I'm going to say that'll probably conclude. Oh, wait, hold up. Every time I do this, there's that question. Does applicable state law apply based on where the organization is headquartered or where the office is?
This is Peggy again. I would say that the law applies to where the person works. So if, for example, and especially in today's world, where people that are working remotely from all over. If you have an employee, for example, who goes to work in California, you really need to make sure that you are following the laws of California. Even, for example, with the California EEO-1 reporting, if you have, for example, just one employee sitting out in California and you're over 100 people, you're responsible to file the EEO-1 in California. So it's important to really pay attention to where people are working. Same thing if you have people working remotely, make sure that you also have them covered with not just the law, but work comp based upon where they're actually working at. Now, I want to add one more thing to that. Somebody typically who is working a hybrid situation, that's really a different situation. So if somebody, like we're in Missouri and we have people that maybe live in Illinois and work 2 days a week in Illinois, their direction and control comes on Missouri. They would come back to that Missouri office as far as what laws are applicable.
Well, if we do not have any more questions, I'm going to say that that concludes today's webinar. And I would like to thank everybody for attending, and a big thank you to our presenters and speakers, Brian, Peggy, and Francine, for their presentation. It was very wonderful and informative. So we look forward. We will have our June information for the webinar up on the website probably later today. So you will be able to register for that. And again, I hope everybody has a great day, and I will make sure to give contact information out for everybody at Synchrony HR. Thank you.
Thank you so much.